Welcome back, everyone, to OpenLine. We are talking with elder law attorney Tim Takacs. He's joining us via Zoom from Hendersonville, and it's always good to have Tim Takacs on. And as we set up kind of the conversation, we were talking about caring for a loved one, that kind of thing, exactly what elder law is, and you laid that out for us. But I always like to also ask, what are some of the cases that you're seeing right now? What are some of the cases that came through your door today or in the last week?
Well, actually, it's interesting you mention that, because I had a case just recently of a concern about undue influence. And just sort of to set the table on what undue influence is it basically what that means is that you have a person who maybe, and typically it may be an older person who has some cognitive decline or cognitive impairment. And then, a family member would approach that person and say, well, Daddy, I'm taking care of you, and, you need to change your will so that I'll keep doing that. Or basically it's I guess a paradigm or whatever you call it is that where a person that maybe is susceptible to undue influence, which basically means you have a loved one that comes to them and says, well, I'll move in with you, but I want to make sure that I get the house when you pass away, or I will, and if I don't get the house, then I'm not going to take care of you. All those sorts of things. It's kind of one of those things that, as lawyers, we always say is it's one of those things when you see it, unfold. You recognize it for what it is.
Right.
So it has a varied fact patterns, and I'm sure all your, we can get calls on that, and people say, well, my brother did this, or my father or somebody else did that to somebody. So I had this couple that came in who I had done estate planning for maybe 10, 15 years ago, who are in their now like late 60s. And the husband has a history of Alzheimer's in his family, and so the two of them came in, and, out of concern that the wife has about, well, it's very possible that there's equally possible that I could die first. And since we have a blended family, both of them had been married before, and they both have children, by other spouses, they're concerned about, say a child coming in of, like, say of the husband, if the wife dies, and that potentially he would be subject to undue influence.
Wow.
So essentially what that would mean is that, they have a very well thought out estate plan for the two of them because they've been married for a long time. They want to make sure that their estate goes, to his children, and that some estate goes to her children. But, but she also wants to make sure that if she predeceases him, that there are her funds would be available to take for his care, and needless to say, vice versa. And she does not want those funds she wants those funds to be used for him, and not wind up in the hands of his children.
So when you talk about undue influence, you're talking about family members coming in and trying to...
You're talking about family. And that's primarily where undue influence comes from.
And so how would you...
Typically not somebody that walks up on the street and knocks on the door, and says, I want to mow your lawn, and the next thing you know, they've got your bank account.
How do you guard against...
Undue influence, basically. How do you guard
against that? What would you do?
Well, one of the things that you do is that, it's very, obviously it can be difficult, because now you're looking at, in many cases, planning ahead. And for instance, maybe, we're going to be having conversations, with the two of them about, setting up a trust. Should we transfer some assets that they have to a trust? Then you have to decide, okay, who's going to be the trustee? Maybe in a case like that, you make the trustee both children from each marriage. I mean, basically from children from each spouse. So you have a brother over here, and a sister over there, who are like, say, co-trustees. So
That's
essentially
smart.
what you have is you have some sort of monitoring system that you set up. So kind of each of them will have an eye on the other to make sure that, they've got, each of them has eyes on the other.
That's really smart. Yeah.
Do those sorts of things.
Wow. Okay.
Yeah. And that's something that you set up, you set up in ahead of time.
And so that's the kind of thing you're seeing. That's fascinating. This kind of coming through your door now.
Yeah. Right.
And are there certain things at this time of year? Does this time of year generate certain time? I know that you say around Christmas you get, things happen because people see maybe some decline in a loved one. Here we are coming at, the summer, the end of the summer. Any special kind of things?
I thought about that. It's kind of hard to say because, on the one hand, you could say that maybe over, since, what the pandemic began in March 2020, it's not like people are just suddenly getting out, and seeing people, which I guess could be true. But, I'm not really sure what accounts for it. They're just, maybe maybe it's just an exceptional run of, cases that, we're seeing and people are bringing the issue to us.
Right.
I don't know.
Let's talk wills for a moment.
Okay.
I'm going to save one of you love trust. I'm going to save that for the next kind of segment. But what do people need to know about wills?
One of the things, a will is basically it's I'll just call it an utterance, okay? A statement or a person, the will maker, is speaking, from beyond the grave, essentially. So a person has a will, a paper writing, that says, okay, I've got these, I've got money in the bank, CDs, stocks and bonds, I've got children, I've got a spouse, I've got whatever it is, and you make out a paper writing that says, this is how I want my assets to go when I'm dead. And that is ultimately that's a will. Now, and we've had this, I'm thinking I've had this conversation before about how property passes when somebody dies.
Right,
there are a number of different ways that happens. One of the ways that it happens is that where the person that potentially the deceased person actually makes an utterance or a statement, which of course is a will, or maybe what the person does is that they have a contract, with a contract that says, well, when I die, a person will be stepping in, and that, and the assets that I have, are going to go to somebody else. That's like a life insurance policy. So you have a $100,000 life insurance policy, but maybe you've got $100,000 cash value, and you name somebody as the beneficiary. So when that person dies, the life insurance company says, well, we have a contract with the deceased person to pay out those benefits. So that money goes to that goes to the beneficiary that's named. That's how one way property passes.
Right.
Another way property passes is by operation of law. So if you die without a will or an estate plan, there is a process, so that if you're married, then your assets go to your spouse first, and then they go to your children, so it goes like that. So every state has a way that assets go when they pass away.
And that's just kind of by law. So that makes you think, okay.
That's by law. That's operation of law.
Do you need a will? I mean, and I know you do.
Many people do not.
Many people, yeah.
That's right.
Yeah. So if I died, it would go to my wife.
Yeah.
I mean, it just automatically goes to my wife.
Right. And actually, in many cases, if for married couples, they come in, they do estate planning with us. And if both spouses are in good health and they stay in good health, and so one spouse passes away and everything goes to the surviving spouse, typically under those circumstances, there's no estate administration, no probate is necessary, because the person left everything to his or her spouse.
We now have a couple calls. Let's go to the phones here. Let's go to Claude. Hello, Claude.
Hello, thank you, gentlemen. And he got me thinking, talking about a will. I done a will about 10 years ago, and I'm curious to think that, do I need to take the will and change anything to make it a trust, or just stay where I'm at, or do I need to go to a trust? And I'd like for him to explain that a little bit to me, and I'll hang up and listen.
Okay. Thank you, Claude.
Yeah, thank you, Claude, because that was right in my wheelhouse. That's where I was headed. Because a trust is like a contract. So you have actually what you can do, if you are you're doing an estate plan, and we do many of these, because our clients, typically will come to us and say, well, we don't want our estate to go through probate, which is another word for what we call court supervised estate administration. In many cases, our clients are saying to us, I don't, my children or my spouse does not need to go through court, a court process called probate, to make sure those assets get from me when I'm dead to either my spouse or my children. So maybe they would set up a trust, where they would name a trustee to take control of the assets of their estate when they pass away. So let's say the parents or the married couple transfer their assets to a revocable trust. Revocable basically means they can always be changed. So they transfer assets to themselves as trustees of their own trust. And any assets in that trust really are for the benefit of for the two of them. But let's say both spouses die, and let's say they've named a child as the backup trustee. So then the trust assets then become owned by the backup trustee, and the backup trustee has a clear set of instructions that says, well, when my parents passed away, then my job as the trustee is to distribute the trust assets out to myself and my three siblings. That is that's basically a trust.
Do you think Claude should have a will or a trust, or it's hard to know, but what would make the difference for him?
It would be hard to know without having a conversation. So let's say Claude calls the office and he sets up an appointment, or if it was if he was calling from an area that was really not an area that we serve, we might say, we know someone, that's local to you, that you should go talk to this person to talk about whether you should set up a trust. There are a lot of different reasons for setting up a trust. One of the reasons that you would do that is, let's say that Claude has children, and let's say, he has children who are, certainly if he has a special needs child, let's say has a child who is born with cerebral palsy or something else, then he would want to set up a trust for that child, to make sure that child doesn't inherit outright. Or let's say he has concerns about his beneficiaries of his estate. Say maybe he's concerned about a child who has creditor problems, or cannot manage money, or is in a bad marriage, and all those sorts of reasons that if he sets up a trust, that's basically what he's doing, is giving asset protection to his children.
Wow, okay.
Because instead of the assets directly going to the children, the trustee could say, well, and I've had countless number of meetings, what we call final meetings like that, where I'll have a conversation with, when our client dies, I'll have that, that has a trust in place. I'll say to them is that, well, in your father's trust, he left everything to you, but trust language allows the trustee to retain the trust assets, for any number of different reasons, which would be essentially appropriate if, let's say a child, that, okay, you had a healthy child when our client made the trust, but that child after several years, the child is not healthy. Well, we can, the trust assets can be retained for that child.
It can protect in that situation. All right, we have to take a break. Okay, Wilma
that's all it is.
Wilma and Renee, hold on the line. We're going to come back to you. We'll take a break. Be back right after this.